The definition of hearsay is deceptively simple, an out-of-court statement offered to prove the truth of the matter asserted in the statement. But what if the speaker didn't intend to assert anything? Does the utterance still constitute hearsay? A federal circuit court answered that question in the 1990 case of United States v. Long. Police officers executed a warrant to search for drugs at Sonia Mayfield's apartment. Once inside, they found Keith Long. The search also revealed cocaine, drug paraphernalia, and a lot of cash. At some point, the house phone rang and a police officer answered it. The caller asked to talk to Keith. When the officer said Keith wasn't available, the caller asked if Keith, quote, still had any stuff, unquote. The officer then asked what the caller meant, and she replied, quote, a 50, unquote. After the officer said yes, the caller asked if someone named Mike could come get it. Long was arrested and subsequently indicted in federal district court for drug possession with intent to distribute. Before trial, Long moved to exclude the phone conversation on hearsay grounds, arguing that the caller implicitly asserted Long was a drug dealer and that the prosecution offered the conversation as evidence to prove that assertion. The judge dismissed Long's motion and allowed the officer who answered the call to testify about the phone conversation. Ultimately, the jury convicted Long, and he appealed to the United States Court of Appeals for the District of Columbia Circuit.